name is Nathan Cole. The date is September 14th, 2019. The time is 8:47 in the morning. I remember that detail because I had just set my coffee mug down on my desk. The old ceramic one my wife bought me at a roadside shop in Vermont, the one with the chipped handle I kept meaning to replace, when my phone buzzed. A calendar reminder. 18 days left. That's what I had been counting down. 18 days until October 2nd. 18 days until 22 years of work would finally, officially belong to me. Let me back up. I started at Caldwell Industrial in the spring of 1997. I was 31 years old, 2 years out of a master's program in mechanical engineering at Georgia Tech, and I had just left a perfectly decent job at a manufacturing firm in Charlotte because the founder of Caldwell, a man named Elias Brandt, had called me personally to make an offer, not his HR department, not a recruiter, him. He said he'd heard about a heat transfer patent I'd filed on my own time, and he wanted someone who thought like that, someone who built things that lasted. I told my wife, Joanna, that night over dinner. She looked at me for a long moment and then said, "If you don't take it, you'll spend the rest of your life wondering." She was 28. We had a 3-year-old daughter and a mortgage we were already stretching to cover. It wasn't a safe move. We took it anyway. Over the next 2 decades, I built the Advanced Systems Division at Caldwell from 4 engineers and a shared conference room into a team of 31, responsible for the proprietary thermal management architecture that sat inside every piece of heavy industrial equipment the company sold. It wasn't glamorous work. Nobody outside the industry knew what thermal management architecture even meant. But inside the company, everyone knew that if you pulled our systems out, the machine stopped working. The patents, 12 of them by 2019, all assigned to Caldwell, were worth considerably more than anyone liked to say out loud. Elias Brandt knew their worth. He told me so once, standing in the parking lot after a product launch in 2011, when we just signed a licensing deal with a Korean firm that added $4 million a year to the company's bottom line. He put his hand on my shoulder and said, "Nathan, you understand that you built something real here." I did. I'd spent 22 years making sure of it. The contract I signed when I joined Caldwell had a clause in it. Elias had put it there himself, and in 1997 I'd almost walked away because of it. The clause said that all intellectual property developed during my employment was assigned to Caldwell. Standard enough, but Elias had added a secondary provision that I negotiated carefully over 3 separate meetings before I finally agreed. It read, in summary, that if the company was sold, acquired, or taken public, and if I had not received my full deferred compensation bonus, a bonus structure that had been accumulating since year 5 of my employment, then a specific subset of the patents, the core thermal management architecture I had personally led, would revert to joint ownership, half the company's, half mine. My attorney had looked at it and said it was unusual. I said I knew that. He said it might never matter. I said I hoped he was right. For 17 years, it didn't matter. Caldwell stayed private. Elias ran it like he'd always run it, steadily, honestly, without drama. He promoted me to VP of Engineering in 2009. He gave me a seat on the product council. He called me by my first name and occasionally my last, depending on his mood, and when our department hit a milestone, he sent handwritten notes. The man was 71 years old and still came in 3 days a week. I liked working for him. I genuinely did. Then, in early 2019, his son came back. I had met Kevin Brandt exactly twice before that year. Once at a company Christmas party in 2006, when he was in his mid-20s and already had the kind of easy confidence that comes from knowing your last name is above the door. Once again at his father's 65th birthday dinner, where he'd spent most of the evening on his phone. He had an MBA from Wharton and a resume that included 2 years at a consulting firm and a brief stint running a startup that had, from what I understood, not gone especially well. He was smart enough. That wasn't the issue. The issue was that he came back with ideas. By March of 2019, Kevin had been named co-CEO. Elias framed it as a transition plan. He was 71, his wife had health problems, and he wanted to start stepping back. That was understandable. Kevin started attending every product meeting, every strategy session. He asked good questions sometimes. Other times, he asked questions that revealed he had a superficial understanding of how the engineering actually worked, and when I tried to explain the technical reality, he would nod in a way that made clear he didn't want the explanation as much as he wanted agreement. By June, he had brought in 2 new executives from outside, a chief revenue officer and a head of corporate development. In July, the word acquisition started appearing in internal communications. There was a company called Meridian Systems based in Dallas. They made heavy equipment for the oil and gas sector. They were looking to expand into industrial manufacturing, and our thermal management technology was, apparently, exactly what they needed. The deal being discussed was significant, over $300 million. I found out the size of the number in August, when Kevin called me into his office and explained that the acquisition would be finalized in October. He said the company was in good shape, that the deal valued Caldwell well, and that he appreciated my contribution to the engineering foundation that had made the company attractive to buyers. My contribution to the engineering foundation. I thanked him and went back to my office and sat for a while looking out the window at the parking lot where Elias had once told me I'd built something real. Then I opened the folder on my desktop where I kept scanned copies of my original employment contract. I had 3 backups, one on an external hard drive in my desk drawer, one on a personal cloud account, and a physical copy in the fireproof safe at my house. My attorney had told me to keep it somewhere safe. I had taken that seriously. I read the clause again. I read the secondary provision again. Then I called my attorney. He read it too. He said, "Nathan, is your deferred bonus still unpaid?" I said yes. The structure was set up so that the full amount, $94,000, would be paid out on October 2nd, which had been established as my 22-year employment anniversary under the original terms. The acquisition was scheduled to close on October 7th, 5 days. The bonus would clear 5 days before the acquisition closed. He said, "Then you're fine. The clause doesn't trigger. You'll get your bonus, and then the sale closes clean." I said, "What if something happens before October 2nd? There was a pause. Then he said, "Then we need to talk." I went home that night and told Joanna. She was in the kitchen making pasta, and she listened to the whole thing without interrupting, which is something she had gotten very good at over 22 years. When I finished, she said, "Do you trust Kevin?" I didn't answer right away. "That's your answer," she said, and went back to stirring. The last week of September, something shifted. I couldn't point to one specific thing. Kevin started closing his office door more. The 2 new executives, the ones he brought in, were in and out of conference rooms with people I didn't recognize. My access to the data room for the acquisition documents was quietly narrowed. Not removed, narrowed. On September 27th, a Friday, I was called into a meeting at 4015 in the afternoon. Kevin was there. The head of HR was there. A woman I'd never met, who turned out to be outside legal counsel, was there. They told me that due to a restructuring of the engineering leadership ahead of the acquisition, my position was being eliminated, effective immediately. I would receive a severance package. I would need to return my laptop and badge before leaving the building. I sat across from Kevin Brandt, and I thought about 18 years of licensing revenue, 12 patents, 31 engineers, and Elias Brandt standing in a parking lot telling me I'd built something real. I said, "Effective immediately. Today is the 27th. Kevin said, "That's correct." I said, "My deferred bonus pays on October 2nd. He said, "Unfortunately, termination prior to the payment date means the bonus is forfeited under the standard employment terms." The outside counsel nodded like she had practiced nodding. I said, "I'd like to have my attorney review the full separation agreement before I sign anything." Kevin said that was perfectly reasonable and that they'd send the documents over. I picked up my coffee mug, not the Vermont one. That one stayed on my desk. This was the one I brought to the meeting, and I walked out. In the parking lot, I sat in my car for 11 minutes. I know it was 11 because I watched the clock. I was not panicking. I was thinking, there is a difference. And learning that difference had taken me most of my adult life. Then I called my attorney. He answered on the second ring. I told him what had happened. He was quiet for a moment, and then he said, "Nathan, pull up that clause." I had it memorized. I recited it to him. He said, "They just triggered it." The next 5 days were quiet on my end. I went home. I told Joanna. She sat next to me on the back porch for a long time without saying anything, and then she said, "What do we do?" I said we wait and let the attorney work. She nodded. She trusted me. That trust cost her something. I knew that, and I did not take it lightly. My attorney filed a formal notice of the IP reversion claim on September 30th. It was delivered to Caldwell's legal department and, separately, to the attorneys representing Meridian Systems in the acquisition. I did not hear from Kevin that day. I heard from Elias. He called my cell at 7 in the evening. He sounded older than I remembered, which surprised me because I had seen him 3 weeks before and he had seemed fine. He said, "Nathan, I need to understand what happened." I said, "Elias, I think you already know." There was a long silence. Then he said, "Kevin told me the restructuring was necessary." I said, "With 5 days to go before my bonus cleared and 7 days before the acquisition closed. You can do that math." Another silence. Then he said, "I'm sorry, Nathan." That was the hardest part. Not Kevin. Elias. I said, "I know you are. What happened over the next 72 hours? I know partly from my attorney and partly from a source inside the company who called me, not as a whistleblower, just as someone who'd worked with me for 11 years and thought I deserved to know." Meridian's legal team received the reversion notice on the 30th. Their attorneys reviewed it on the morning of October 1st. By the afternoon, Meridian had paused the acquisition. The pause was not a small thing. A pause at that stage of a deal creates what is politely called uncertainty, and what actually means that the institutional lenders involved start asking questions, the equity partners start asking questions, and everyone's confidence in the timeline, which in an acquisition is everything, begins to erode. Caldwell's outside counsel contacted my attorney on the evening of October 1st. They proposed a resolution, pays a $94,000 bonus retroactively, argue that the termination had been an administrative error, and proceed with the acquisition as though nothing had happened. My attorney called me at 9 p.m. and relayed the proposal. I said, "What's the full picture?" He said that beyond the bonus, the reversion clause had created a legitimate joint ownership claim over the 4 core patents. Those patents were the primary asset justifying Meridian's valuation. Without clean title, the deal couldn't close at the agreed price, possibly at all. We were talking about a structural problem, not a paperwork problem. I said, "What do I want?" He laughed quietly and said, "That's the right question. What do you want?" I thought about it. Not for long. I said, "I want what was owed. I want it documented. I want my name on the work I did. And I want to never have to think about Kevin Brandt again." We negotiated over the next 48 hours. The final agreement included the $94,000 deferred bonus paid in full, an additional settlement for wrongful termination under the circumstances of the IP clause, a formal acknowledgement in the patent records of my contribution to the 4 core technologies, and a non-disparagement agreement that ran both directions. The acquisition of Caldwell Industrial by Meridian Systems closed on October 14th. 1 week later than originally scheduled, Kevin Brandt's role in the combined company was, from what I was told, significantly reduced from what he had expected. I don't know the details. I didn't ask. On October 15th, Joanna and I drove up to a lake in western North Carolina that her family had been going to since she was a child. We hadn't been in 4 years. We got there in the late afternoon and sat on the dock while the light went flat and orange over the water. She had a glass of wine. I had a beer. Our daughter, she was 25 by then, finishing a nursing program in Nashville, drove up the next morning and had breakfast with us. I didn't feel the satisfaction I thought I would. That's the honest answer. I had imagined, somewhere in the back of my mind, that there would be a moment of clean triumph. There wasn't. What there was instead was something quieter, a sense that the thing had worked out the way it was supposed to, not because I had been clever or strategic, but because 22 years ago a man named Elias Brandt had written a clause into a contract that said, if they don't honor what they owe you, then what you built doesn't fully belong to them. And I had read that clause and understood it and kept 3 copies and never let myself forget what it said. That's not a revenge story. I know it looks like one from the outside, but from where I sat on that dock in North Carolina, it was just the end of a very long job. I retired at the end of that year. Formally, with paperwork. Joanna made dinner, the good pasta, the kind she saves for occasions, and we ate at the kitchen table with all the lights on because she hates eating in dim light, always has. And I had spent 22 years traveling for work and eating in dim restaurants, and I sat there in my own bright kitchen and thought that was probably the best thing I could say about how it ended. There are things I would tell a younger version of myself, if I could, not about revenge or leverage or how to protect your work, though I'd tell him those things too. I'd mostly tell him this: read the contract, read it carefully, ask for the thing that protects you even when it seems unnecessary, because the other party will always tell you it'll never matter, and sometimes they're right and sometimes they're not, And the only way you'll know the difference is if you are paying attention from the beginning. Keep your documents somewhere safe, more than one place, and know what they say. That's all I've got. I hope it was useful to somebody. I've had a lot of time to think about what actually happened. Not the legal part, not the clause, not the phone call from Elias at 7 in the evening. I mean what really happened. What set all of it in motion, long before September 27th. Kevin didn't fire me because he was cruel. He fired me because he was careless. There's a difference, and I think the difference matters. Cruel people know what they're doing. Careless people don't bother to find out. He saw a line item, a $94,000 obligation sitting 5 days away, and he saw a cleaner balance sheet if that line item disappeared. He didn't read the contract carefully. He didn't ask the right questions. He assumed that because his name was going on the door, the details would sort themselves out. That assumption cost him more than I ever could have planned to take. I'm not saying I was the better man in every room, every year of those 22 years. I wasn't. I was impatient with people who moved slower than I did. I took Elias's trust for granted more than once. I missed things at home because I told myself the work was important enough to justify it, and sometimes it was. And sometimes I was just hiding in the office because the office was easier than being present. Joanna never said that to me directly. She didn't need to. But here's what I did do. I read the contract. I kept the copies. When my attorney told me the clause might never matter, I said I hoped he was right and kept the copies anyway. That wasn't strategy. That was just paying attention over a long period of time, which is maybe the least glamorous version of intelligence there is. Nobody makes a movie about the guy who files things carefully. But the filing is what held. What I want people to take from this, if there's anything worth taking, is that the choices you make when nothing is at stake are exactly the choices that determine what happens when everything is. I negotiated that clause in 1997 because it was the right thing to protect, not because I thought I'd need it. I kept the documents because Elias had told me to, and he was a careful man, and I trusted careful people. I called my attorney from the parking lot instead of going back inside and saying something I'd regret, because I'd spent enough years learning that a quiet exit buys you more room than a loud one. That's not intelligence in the way people usually mean the word. It's closer to integrity, which in practice just means doing the boring, unglamorous, unrewarded version of the right thing consistently enough that it eventually adds up to something. Kevin didn't lack intelligence. He lacked that consistency. He never had to build anything slowly. Everything in his life had moved at the speed of the last name above the door, and when he finally needed to understand the structure underneath the speed, he didn't have the patience for it. I don't hold it against him, I genuinely don't, but I do think it's worth naming because I've watched a lot of people make the same mistake in smaller ways. They skip the fine print. They let the relationship do the work the document should do. They assume good faith is a substitute for clear terms. It isn't. Good faith is what you hope for. Clear terms are what you fall back on when hope runs out. Joanna and I sat on that dock in North Carolina for a long time that October evening, and I felt something subtle. Not triumph, just the particular quiet of a thing finally being finished. Build carefully, protect what you build, and when someone tries to take it without honoring what they owe, let the paperwork speak.